I want to know what they're trying to get at.
We're back on the record. This is the meeting of the Senate Committee on Government Operations for Tuesday, April 15th, halfway through the month. And we're joined today by two legislative council members. Eric Fitzpatrick, who's in the witness chair at the moment, and Tucker Anderson is also with us. And we're beginning to consider amendments to S-131, which is the Burlington Charter. I don't think there's any need for us to introduce ourselves again. I think we've all gotten to know each other pretty well. So, Eric, good to see you.
Yes, thank you. Good to see you, Mr. Chair.
So I have two amendments, and I'm assuming that 1.1 is not going to be considered today.
Correct. Hopefully, one of the ones you have is.
It is.
Yes, please.
And which one back is yours?
Becca's not here. But Becca and I have been in conversation, so
Yes, and I thought I
This
was
replaces
with that.
yes,
too.
2.1 replaces 1.
Okay. All right, that makes it easy.
Yes.
So if you could walk us through it, tell us what is different from 1.1 and what is different from the original bill, that would probably be helpful.
Yes, happy to do so. Eric Fitzpatrick with the Office of Legislative Counsel. Here, as the chair said, to talk with the committee about a proposed amendment to S-131, which is an act relating to approval of an amendment to the Charter of the City of Burlington relating to the possession of firearms. Just for a moment to refresh everybody's recollection as to why there's even a proposed amendment in front of you, which is Senator Vyhovsky mentioned. She and Senator White and Senator Carson as well had all been in contact about this possible proposed language. At the moment, it's just proposed for the committee to think about. But what led us to this point was that the language that was initially passed by the city in the proposed charter change, you may recall, in our office, we identified a couple of constitutional problems with that language. And the language you have in front of you is an attempt to address those constitutional concerns. And specifically, the language as it passed, you may remember, if it were read in a plain language sense, literally, straightforwardly, it appeared to prohibit the possession of firearms by anybody on any property that was owned by a place that was licensed to serve alcoholic beverages, whether or not that property was inside the establishment, in the parking lot next door, upstairs, in another building that the establishment might own in another part of town. Unlikely, I don't know for sure, didn't have anything to do with it, but unlikely that was the original intent of the language, but that is the way it read. And that was the first constitutional problem with it, is that it was constitutionally vague. So it's unclear. Another than vagueness, the constitutional vagueness is a due process principle that means basically that a reasonable person has to be able to understand what conduct they can't engage in order for it would be supposed to be criminal. Otherwise, it's obviously a fundamental fairness problem. So whatever was intended, it wasn't entirely clear. So that was one issue. And the second issue was a Second Amendment issue under the Second Amendment to the United States Constitution, which protects an individual's right to possess firearms for self-protection. And the issue there was that, and this goes back to a couple of years ago, a United States Supreme Court case called New York State Pistol and Rifle Association versus Bruin, that laid out the test that you have to consider when you're seeing if state regulation of firearms is constitutionally permissible under the Second Amendment. One of the permissible places of regulation under this Bruin case is what's known as sensitive locations, sensitive places that identified a few in the case. And as it happens, you have a federal case from the United States Supreme Court, United States Circuit Court of Appeals for the Second Circuit, within which Vermont sits. So it's controlling law from just a few months ago in October, called Antonin v. James, sorry. And one of the places that was looking at New York's firearms law and happened to address the exact issue. New York had a statute on the books that prohibited possession of firearms in places that serve alcohol. The court, Second Circuit, upheld that in places, I'm stressing the preposition there, in places that serve alcohol. So under the current Second Amendment jurisprudence, at least as it applies right now in Vermont, part of the Second Circuit, controlling law, you can, it is permissible, in my view, to prohibit possession of firearms in places that serve alcohol. Now, Supreme Court hasn't said anything about this issue yet. It's certainly always possible that that could change down the road. But right now, at this moment in time, reading the controlling law that applies to Vermont, the regulation prohibition of firearms in these places that serve alcohol, looks okay. The problem was when you look at the language, it was not limited, as I mentioned, to places that serve alcohol. Again, it was property that could be located elsewhere, that the establishment owned. It could be a parking lot, could be an adjoining facility. It really wasn't clear. So that's why you have to, sorry.
That's okay. Thanks, Eric. Let me just see if I can pose the question intelligently here. In the Supreme Court decision, there was no mention specifically of places that served alcohol. It just said sensitive places. Is that correct?
It listed a few, but not this, that's right. It didn't list places that serve alcohol in that case, correct.
So the Second Circuit decision seems to be kind of flying in the face of the Supreme Court decision. I'm just asking whether that's true or not.
I don't think so. I don't read it that way because besides listing a few specific sensitive places that were okay, the Supreme Court decision listed like courthouses, schools, polling places, legislative assemblies, appropriate to your word there. It did list a few specifically, but it also said that you could add to that, courts would be able to add to that list, provided they had to go through this, you may recall me mentioning last time, you have to go through a historical analysis and see if, to use the sort of language from that Supreme Court decision, whether this newly proposed sensitive location was consistent with the nation's history of firearms regulation. And as it happens, there's been two appellate court cases, the Second Circuit one I just mentioned in October, and one from the Ninth Circuit in California the month before that in September, that did go through that analysis, that went through the history and said, hey, there's this statute from the Oklahoma Territories in 1880. There's another one from Arizona. There's city ordinances in, I think one was New Orleans and one was, I'm not sure, there's another city in addition to New Orleans, but they looked at these and they found some historical examples of where firearms had been prohibited in places that served alcohol. And those courts said, hey, based on that, we're gonna conclude that there is that prohibiting firearms in places that serve alcohol is consistent with the history of firearms regulation in the country, using those examples. Now, that doesn't mean that, it's an interesting task, this process of deciding how many historical examples do you have to have before it becomes part of the nation's tradition. Because some courts have looked at in other areas have said, well, there's only one or two, that's not enough to count as a tradition. So that's why I fall back on the fact that, well, in this particular instance, the work is already done for the Vermont legislature because the Second Circuit happens to have already ruled on the question of places that serve alcohol. Supreme Court hasn't. So it's true that ultimately Supreme Court could look at the same issue and reach a different conclusion. Can't predict that. But for now, Second Circuit looked at what it found on the books historically and said, this looks consistent.
Okay.
So we're gonna hope.
And I know you're going to get to the exceptions next. And I didn't learn until today, there are actually 4 licenses in Vermont having to do with alcohol. There's a first class, second class, third class, and fourth class. We're calling out just the second class licenses here. The first, I'm trying to remember, one of them is the stores that sell alcohol.
Yeah.
And then there's a first class where you can only sell beer and wine. And then I think a third class where you could sell spirits along with beer and wine. Does that ring a bell?
Yes, this is Tucker and I do this every year with our liquor bill.
Okay. Well, I wasn't
Yeah, I know.
that focused on it. So, and Tucker reminded me today of the fourth class, which is kind of like testing at different
Sampling.
locales.
Like
Okay.
a wine store that might have the same, like.
Yeah, or a brewery.
Oh, right.
Or you were gonna add something.
Nope. Okay. Okay. I'm sorry to interrupt, Eric. These are all questions. Okay.
And Senator Palmer, that is a nice segue to when Tucker comes up, because I didn't know much about that either. That's his area, not mine. So we'll be able to give you much more detail about that. But you'll see right in the beginning, turning to the language for a moment, at least the part that's more related to firearm. If you look at page 1, I'm looking at, again, version 2.1 of the amendment.
Yeah.
you'll see the way the charter was originally written. I'm looking at lines 15 through 17.
I'm sorry, on the amendment or on the?
On the amendment, on
Yeah,
section
right there.
2.1.
Page one.
So it's highlighted in yellow. I'm sorry, I should have added that. Changes between the charter as passed by the city, which was S-131 as introduced, and the amendment are highlighted in yellow. So if it's not highlighted, it's the same language that was passed by the city. So
Okay. Yep.
again, looking at lines 15 through 17, page 1, you'll see again that the language passed originally applied to firearms in any establishment with a first-class liquor license. See that? So that's actually, as Senator Clarkson was mentioning, I believe that the first-class liquor licenses only apply to consumption of beer and wine for consumption on premises. So in other words, it's leaving out just one thing that's left out just from the title. For example, liquor served on premises, right? But then if you looked at the term for a moment over to page 2, lines 3 and 4, the substance of what was passed in the charter applied to an establishment licensed to serve alcohol on its premises. So that's not consistent with the first class liquor license that was in the title. So that was another vagueness issue that had to be addressed in this amendment. And the way that was done, you'll see, go back to page 1 again, is to change the title to a more general statement that the ban applies to see the preposition in there, line 15. So that's still the same though. In premises licensed to serve alcoholic beverages. So it speaks generally, but then as you mentioned, Senator Coleman, you'll see some exceptions that will carve out a few of the licenses. So it's not going to include every particular type of license when we get to that. But before we get to that, let's look at the substance subsection B. What is actually banned now? Again, in this proposal, you'll see again that I mentioned as passed that the language applied, and this is the struck through language on lines 2 through 4. In any building or on any real property or parking area under the ownership or control of an establishment licensed to serve alcohol. So that's the broad vagueness issue that I mentioned earlier, as well as the fact that the Second Amendment cases that I referred to apply to prohibition inside the premises, not these other locations. So that language is struck, and the proposal is to make clear that the prohibition applies in, starting on line 2, in any, and then you go on to line 4, in any premises licensed to serve alcoholic beverages. And also added is a mental state on line 1, knowing that language is in our other sensitive place statutes as well. The polling places that we have in the books in Vermont already, courthouses, schools, hospitals. The idea being there that you don't want to criminalize somebody who inadvertently has a firearm and either didn't remember that they had it or something like that. So that's the idea of having the knowingly statute in those places. So it requires the person know that they actually possess it, and that they're actually in the premises. There's some less of a concern since you're talking about inside the building, but there's some cases where people want to be certain that, like, for example, school grounds. Maybe you don't know that you're on school property. So that's one of the reasons that nothing is in there in other places. So the idea here is that by making the prohibition apply inside the building licensed to serve alcohol, that you're consistent with both the Second Amendment and it's no longer vague. It's clear what conduct is that's prohibited. And that again moves on to the exceptions. In other words, what type of licensing applies here? And that's, I'm going to defer to Tucker on that. It's just one thing I want to mention before I do so. Didn't make any changes here, just so the committee's aware. There's also a forfeiture provision in this. It starts on the bottom of page 3, goes over onto the top of page 4. This permits the person's firearm who is convicted of a violation of this provision. In other words, they possess a firearm in a place that serves alcoholic beverages, permits the person's firearm to be forfeited in a proceeding following their conviction. And on its face, not unconstitutional on its face, but want the committee to be aware that forfeiture provisions do raise constitutional issues that could come up later on. It all depends how this process would work out. How would it, for example, there's a kind of a proportionality requirement for forfeiture that if the property forfeited is vast, significantly valuable, and the offense doesn't seem particularly serious, that a person can make a claim that that's a excessive fine in the Eighth Amendment of the Constitution.
Senator Duhovsky.
So based on our conversation, my understanding is that, and please correct me if I'm wrong, is that if I want to hear what the city's trying to do here,
Mhm.
but if this were removed, they would still be able to take the firearm in the moment where it's in the bar, because that is sort of the implement of the crime, but then would have to give it back.
Absolutely would have the ability to take, it's an instrumentality of crime is the phrase that's used often. So that in this particular case, the firearm is evidence that the person violated the prohibition of possessing firearms and fire. So they absolutely would be able to take it for the remainder of the court proceeding, to use it as evidence in the court proceeding. This is what the person had. And then it would come down to how evidence is covered by the law enforcement agency's general approach to evidence that they've taken for instrumentalities of crime. Many times they try and return it. Many times the person doesn't take it. They might have to sell it after that. But they have a general, law enforcement agencies have a general approach toward how to deal with that.
And that exists with or without this.
Exactly. That
Sure.
independently exists. Yeah. Okay. And that's pretty much the firearms pieces that I wanted to cover, but happy to answer any questions or turn it over to Tucker for some talk about the licensing issues.
Just, I mean, I know this was in the original bill, and maybe it came up, I'm just not remembering. Probable cause is a phrase that I'm trying to understand definitionally. And also preponderance of the evidence, as I recall, is the least amount of proof needed to do something. Clear and convincing is the next step, and beyond a reasonable doubt is the third. Is that correct?
You got it. Yep.
So what is probable cause?
Well, I do have a memo on that I don't have right handy, but one of the sentences from the Vermont Supreme Court that I always recall about probable cause is that it's incapable of precise definition, but it's what would lead a reasonable mind to believe that the facts support a given, in this case, criminal offense. Facts taken together support the conclusion that the offense has been committed.
Okay.
By that
Any
person.
other questions for Eric? Yes, Senator White.
Thank you, Mr. Chair. A dining car for which a licensee holds a promotional railroad tasting permit.
Mhm.
Is that going to happen in Burlington?
Yes.
I was
Defer to my colleague, my esteemed colleague.
on the train.
I know,
Every
but
year.
there's a train within the Burlington. Okay, great.
It's a dinner train and it goes from Burlington to Middlebury and serves a full meal and has a bar car.
I love this. Didn't
Yeah.
know.
Yeah.
Great. Thank you. Question answered.
You have to be trained right.
Not to drink though, and not with a gun.
One or the other, but not both.
Thank you, Eric. We appreciate it.
Yes. happy to help.
You're pleased with our constitutional language here. You feel like, I guess I'm a little puzzled that Burlington, with all its resources, didn't get a constitutional lawyer to actually
Well,
draft.
Well, we have two witnesses coming up that
I know.
help us.
I know, it's just a puzzlement. Anyway, but you've got the.
I think under current law, as much as you can be certain at the moment, because like I said, you never know exactly what the Supreme Court will do down the road. But yes, under the current controlling Second Circuit
I
precedent,
think we're okay.
yes,
Great. That is so, thank you so much for doing this.
you're welcome. Happy to help. Any other questions? Let me know for sure.
Tucker?
Well, good afternoon, SGO, Tucker Anderson, Legislative Counsel. I'll work through subsection C of the amendment with you all, but first I wanted to do some place setting around alcoholic beverage licensing.
Yes.
And the reason for that is that subsection C is going to call out specific exceptions, but I want to build you a picture of what will be captured before we talk about what is accepted under the subsection. So the chair pointed out that you do have 4 numbered licenses, first, second, third, fourth, but there are a whole host of other licenses for purposes of Title VII. The list is quite long and perhaps even growing. First class licenses, as you pointed out, allow for the on-premises serving of malt or vinous beverages. Second class allows for the retail sale, that's closed containers for off-premises consumption. You can think of those as your gas stations, your liquor stores, like the 802 Spirit stores. Third class licenses allow for the on-premises sale of spirits or fortified wines. Before anyone gets anxious, there is a fortified wines permit that can be granted to second class locations for the sale of closed containers, which is of course, separate permit. When I first walked through this bill with you all, I noted that the scope of what is serving alcohol on premises and the licenses associated with it is quite long. And it goes all the way from traditional bars and restaurants to indeed the dining cars on trains. And I'll talk about some meaningful legal distinctions between the permit that's enumerated here and dining cars generally, to boats on Lake Champlain. Right, all the way down to your festivals, wine poured by the glass at bookstores and art galleries, outside serving permits, farmers market stalls, right, on premises service. The scope of it and the availability of alcohol under these licenses is quite broad. So with that in mind, I worked with members of the committee to focus on what is a premises for this purpose. In the exceptions, you have carved out in subdivision 1A, second class licensed premises. Now, traditionally, these would not even be included because they do not serve alcoholic beverages for on-premises consumption, except that they can get a permit to allow for tastings on location. And suddenly that second class location is converted into an on-premises serving location. Furthermore, premises does not mean a building alone. It can mean designated areas within a building. And you do have certain types of licensees, primarily manufacturers, that operate under multiple overlapping licenses, where they have designated areas, for example, for second class retail sale. So 1A carves out those retail spaces and retail locations, even when they are serving for on-premises consumption for those retail tastings.
Senator Clarkson.
No, I answered my own question. It doesn't account for premise being considered outdoor at a farmer's market or elsewhere because that's not a second class license.
But we're gonna get to the
We're gonna get
outdoors
there, I know.
or some of the outdoors right now.
But premises then becomes the stall,
Right.
right? That's what
It becomes the serving area, which has to be,
Designated area within the sport. too.
Right, exactly.
which has to be demarcated. And for example, at your festivals, the entire festival space becomes a premises, right? Designated area, and then the liability and responsibility for individual licensees is their individual stall or serving area.
Right.
All right, did you have a question?
Not yet.
Okay.
In subdivision B, this exception is for outside premises for which a licensee holds an outside consumption permit. This could be your first or third class license holder, so bar or restaurant that has a designated area outside of the building where they provide alcoholic beverages for on-premises consumption. The term premises is specifically called out in this permit section. That premises extend to the outside when you have this permit. It's referred to as the outside premises of the licensee. This was flagged just to alleviate any ambiguity where the outside premises is the street or the sidewalk.
Okay.
Or in the case of this specific municipality, since it is their charter, Church Street.
So a question for you.
Yes.
If this exception were not included, would that mean that Church Street as a whole is now, like, is that what we're trying to thread here? Because my understanding of sort of the premises is that it's like what's cordoned off as part of the bar and not what spills out into the street that is not the bar. That was a really messy question.
I think I tracked all of it. So what I will say is that the policy choice that you've made in carving this out is to eliminate any ambiguity.
Mhm.
And it is married to the concept of, Eric talked about whether you know when you're on school grounds,
Mhm.
right? Making sure that we have knowing
Mhm.
mental state captured here. Acknowledging that it may not be legally necessary to capture this.
And that's what I'm trying to get at, because
There are these public ways, I'm so sorry to interrupt,
That's okay.
where the serving area is actually bisected by the pedestrian walkway,
I.
right? And that's some of the mess where you've made, at least for now, the policy choice to eliminate enforcement confusion
Mhm.
by just taking those sidewalk areas out of the.
Yeah, and that's sort of what I'm trying to understand, because I certainly understand, school grounds can be not easily marketed, but certainly most of the places where one might sit down and have a cocktail on Church Street usually have fencing around them and are quite clearly demarcated.
Yeah.
So,
Just a ribbon.
yes. So I've just, yeah, it's a policy decision and we included it in here to eliminate any ambiguity, but I do think it's important to make discussion. Thank you.
In subdivision C, and there are 2 technical corrections that will have to happen here. I wasn't wearing my glasses when I typed this subdivision. The premises of a limited event permit, special event permit, or special event serving permit. Getting into the distinctions here, it's very nuanced, but you can think of these, one of these permits covers bookstores, art galleries, places like that, where you have a 4-day limited permit for service in that particular retail space. Special event permits, these are pop-up locations primarily. There's a limited number of days where a licensee can have a special event in any calendar year. And the special event serving permits used to be called educational permits, and these relate to limited duration educational tasting events.
This is not Brewfest, correct?
This is not Brewfest. Those were termed limited event permits, just last biennium.
But this includes limited event permits.
Excuse me, whatever festival permits changed to are not included here. I will have to go back and look at what the specific name that was given to festivals, because they didn't want to confuse other types of festivals that were not dedicated solely to the service of alcoholic beverages.
So instead they confused this. No,
I am confused at the moment, but I will be less confused when I pull up Title VII and give you the name of what festival permits are now called.
Right, in Senate Economic Development, we have changed this and these definitions on a steady beat for the last 6-7
just
years.
as long as it's not Brewfest.
In
No, it's not.
executive biennia, there was a change to festival permits and then subsequently a shift away from festival permits.
Exactly. So these more specific permits.
In subdivision D, this excludes dining cars for which a licensee holds a promotional railroad tasting permit. Again, this is a policy choice. I don't see any particular legal issues here, but I would note that this is not the only license that applies to railroads. Dining cars are considered premises that are capable of being licensed as first or third class locations. So the dining car that you referenced earlier that comes into and out of the city from other municipalities, that may very well be just a first or third class licensed premises that happens to move in and out of the city of Burlington.
What about boats?
Boats are also licensed as first or third class locations, premises. So the Spirit of Ethan Allen is an example of a boat that is likely licensed as first or third class.
But it doesn't need to be called out with regard to the same rationale as used with railroads.
Well, the railroads have not been carved out largely. It's just this one particular type of casting permit that
Oh.
has been excluded.
Okay.
That is all for the wild world of Title VII, your lovely alcoholic beverages and cannabis title. Happy to answer any questions that come up. I will crack open a copy of Title VII and send you whatever the name of the festival permit is. The too long didn't read version of the licenses that are captured here. First, third, fourth, clubs, not like, but the American Legion, the Elks,
okay.
the Moose Lodge. Yeah,
It did communicate.
It did.
Senator Wade.
I apologize because I realized you're trying to wrap up and leave, but I just had, one question, which is we didn't really touch on, and maybe you did, and I apologize, I'm trying to. But on page 3, the owner operator of an establishment's license to serve, who is the owner? Who is the operator now with these new definitions?
That is actually a very good legal
Oh,
question.
good question.
So you should likely ask for some clarity
Okay.
because there is a policy choice involved here.
Yeah.
Because in all likelihood, what we're talking about is the license holder,
Yeah,
right? Person who's operating the licensed establishment. But there should probably be some clarity about whether that is the owner of the premises.
So the owner
Which-
of the building versus the owner of the business.
yeah.
Right, because
Or the
many-
license holder.
Many of these spaces are in fact leased
Yeah.
spaces.
So,
Yes.
so why wouldn't we just then say the license?
If that is the policy choice that the committee would like to make, we can certainly draft that.
I think we also want the owner of the building though. To be
Why?
covered. If you
Why?
own a building and you're walking through a building and you have a firearm, I think you should be allowed to have your firearm in your building. Even if you rent to a business establishment inside that building.
Oh, I see, because this is still an exception.
Yes.
So this is like I own I'm David Briggs and I rent out I rent to the Tucker Box. Am I allowed to have a gun on the premise or is it Burl who has the liquor license? You know, like what's the,
Well, are you consuming alcohol? So to me, this is a question, which is, okay, so an owner could be walking through, but if they've been consuming alcohol, that's a problem.
yeah, I think if you own property, you should be allowed to have a gun on your owned property.
So I didn't change anything in here beyond the constitutional questions because I wanted to hear from the city of Burlington. If
Oh, yeah, yeah.
what their intent was, because I also have flags on the forfeiture issue.
Oh, okay.
But I do want to hear from the city of Burlington as to what they're trying to do before I start because this is a charter.
Right.
If it were statewide policy, I'd be in a different space.
Right.
But so there may still be changes that need to happen in here.
Okay.
I just hadn't yet heard from the city of Burlington as to what their intent was.
And I'm fully supportive of this charter.
You could probably work.
Any other questions for Tara?
Thank you.
Thank you. So I see 2 people on the screen, Jessica Brown, who I think is the city attorney, and also the mayor. And welcome to Emma Mulvaney Stanek as well. Do either of you have time constraints in terms of which order you go in?
If either of us do, it's probably the mayor, so I'll defer to her.
I
So
was
let's,
described as one of the busiest people in Vermont the other day, but I think legislators during the session are also busy. I have until 3 o'clock.
okay. So very quickly around the room, because I don't think either of you have been in the committee this year.
Senator Hart, Orange County.
Emma, it's good to see you. Allison Clarkson, Windsor County District.
Brian Collmore representing the Rutland District.
Jillian, committee assistant.
Tony Vigilowski, Chittenden Functional District.
Becca White, Windsor County District.
So Your Honor, welcome. It's great to see you. And we have some questions just come up with respect to how this was drafted, and we'd love to hear your input.
Thank you. I'm going to provide just some testimony, and then my city attorney Brown, and I can probably tag team those questions as we get into it. And first of all, thank you very much for allowing me to testify. I was a state legislator just last session, so it's nice to be back with colleagues again, and thank you for the time. Chair Callamore, thank you very much, and good afternoon, senators. For the record, and for your record, I'm Mayor Emma Mulvaney Stanek of Burlington, and I do thank you for letting me testify today on S-131, Burlington's proposed charter change that would allow us to ban firearms in bars. The city of Burlington strongly supports this effort, and we have done so for more than a decade. The first time Burlington voted on this charter change, 68% of voters supported it. Now, a decade later, our city council voted unanimously to once again put this question on the ballot, and the measure then passed with over 86% of the vote just this last town meeting day. So as the mayor of Burlington, I'm imploring you to act and to push this measure forward so Burlington can move forward with this common sense gun safety measure. Last summer, just a few months into my still very new term as mayor, we experienced a fatal, tragic shooting at Red Square, which is right on Church Street. That incident was tragic, a tragic reminder that firearms and alcohol are a terrible combination. I met with the owners and the staff of Red Square shortly after this event, and it was a clearly traumatizing incident for everyone involved. It revived the citywide commitment to getting this law passed, and Burlington residents responded swiftly and strongly, and that is what we're here today to ask you to do as well. This charter change may not be the end-all solution to the challenges with firearms violence I acknowledge that. However, it is important and a pragmatic response and a critical step forward in ensuring we have a clear, enforceable rules around gun safety in our city. In fact, Burlington voters are not alone in supporting this ban. 15 different states, including Texas of all places, and Florida, ban guns in bars. And polling shows that 93% of Americans think people should not be allowed to bring guns into bars. Right now in Burlington, some establishments already ban guns, but when we have a law in the books, that ban on guns in bars, that means that we can also leverage our own law enforcement in the city to help ensure patrons are following that law. Bars will not be left alone to enforce this on their own, and that will be the job of our local police department. And if people refuse to comply with the law, those people can be held accountable under this law. It also means we can leverage city resources to support our downtown businesses and their staff in other ways. For example, bar owners that I've spoken to in this last year who want this charter change have also asked for de-escalation training and other training around best practices and protocols for implementing this law in their establishments. Again, that is something the city is very happy to provide. As I continue to talk to bar owners and late night establishments, I've actually heard from folks, they want the peace of mind, and so do their customers and their employees, and our city employees for that matter, downtown late at night, because they will have that peace of mind knowing that guns are no longer in bars in the city, citywide. And that, in their mind, will bring more people downtown. This is something that is a critical economic need for the city of Burlington. There's a safety need for the city of Burlington. And anything I could do as mayor to advocate for folks feeling like they can come down and enjoy themselves and be here safely, we will support. So thank you again for honoring the will of Burlington's voters and taking up this bill. And I hope you'll continue to support our efforts by advancing it forward. And I'm happy to answer any questions along with City Attorney Jessica Brown. Thank you.
Thank you very much, Your Honor. Does anyone have questions for Emma? Senator Bielowski.
I do. Thank you, Mayor Mulvaney Stanek. So a lot of my questions are really around intent as we try to craft the language that does what the Burlington voters are asking and stays in the bounds of constitutionality. And so my first question around intent is the section on forfeiture and what the city is hoping to achieve with that forfeiture piece added in.
Just skimming down to your version of the bill today, and I might lean on my city attorney here too, just on the drafting side of it. City Attorney Brown, do you want to speak to that?
So thank you. For the record, I'm Jessica Brown, Burlington City Attorney. Thank you all for inviting us to speak and answer questions about the charter change language. As you may or may not know, we used the exact same language in this charter change proposal as was drafted in 2014, the first time that Burlington voters voted to in support of this charter change. So I, in anticipation of that you may have some questions about the intent in drafting the language as it was drafted, I ultimately connected with former Burlington City Councilor Norm Blaze, who indicated to me that that whole section about the civil penalty and forfeiture, his recollection, he was involved in drafting the ordinance language in 2014, and his recollection was that the intent was simply to create a non-criminal option for incidents that maybe didn't rise to the level of requiring an arrest or criminal response. They wanted to have a provision that provided for a civil penalty, and they included forfeiture as part of that.
That is helpful. And I guess I wonder, and this may be for one or both of you, given the council's sort of question as to whether or not it might be viewed as too big, permanently taking the firearm may be too big a response to a non-violent crime. Would it, if we sort of ultimately come to that space, where would you all land on that language potentially being removed?
I'll note that I think, to your point, Senator, if there is, for example, violent behavior or violent use of the firearm, there are criminal responses that could result in seizure of the firearm. So if the committee ultimately finds that the ordinance should not specifically include language, forfeiture language, I don't think that I think that there may be other options for specifically law enforcement to seize firearms in certain circumstances.
Yes, and we did hear testimony from legislative counsel that is true. I just want to make sure that as we're changing things, we're not wildly getting outside of the intent of the language. The other question that I wanted to ask, so one of the ways that we attempt to alleviate ambiguity is by exempting outdoor serving spaces, like, the patios on Church Street. And I just want to hear your thoughts on that.
Mayor, do you want to speak to that?
Sure, I can begin and then you can fill in,
Sure.
City Attorney, if that's helpful. I just want to be clear that the City of Burlington, what we're really looking for here is a measure that will help us with our community safety. We very much support and appreciate the Senate's ability to narrow this in a way that really threads that important needle around. I'm sure you've discussed the Bruin case and where a court, we want to say within the parameters of what the court's interpretation has been to date. Everyone hopefully has come to Church Street, will keep coming to Church Street, and knows that we have a lot of establishments that I think I heard your legislative counsel describing, where we have pass-throughs where people walk between the physical building of, for example, Red Square, and then there's a whole patio set up that's part of the design of Church Street where people are enjoying the outdoors, and has allowed, especially during COVID, additional space for our restaurants and bars to set up shop, have more customers, have more space to serve and run their businesses. So I think it would create a little bit of confusion, but at the end of the day, what we really want is to be able to advance common sense gun regulation, to be able to make sure folks are clear what the rules are. And I also want to make sure that our law enforcement are also clear what the rules are, and the staff who are working in these late night establishments. We could certainly deliberate a little bit more on that. I want to talk with our city attorney a little bit more offline on that. This is the first I'm seeing this piece. But I would encourage you to think about clarity. People don't really know the difference between sitting out in as you were saying, Senator, a well-marked patio versus being inside. I think in general, our position is still very clear that guns and alcohol do not mix, as it has been shown by 15 different states, including Texas, for which my wife's family is from. And I think that's really smart policy, frankly. And we want to make sure we have a safer Burlington. So I think it would create this is my long-winded politician way of saying, I think it would create some confusion, but I want to make sure I'm not missing something with my team, and we can double back. City Attorney, do you have anything to add to that, just in case I missed something there?
Senator, were you gonna say something or ask another question?
Go ahead, I want you
Okay.
to get the name, yeah.
Thank you. I'll just add that I was listening to Legislative Counsel earlier discuss the Bruen case, and I do agree with his interpretation that while the opinion identified some specific commonly agreed on sensitive areas, it also left open that there may be other sensitive areas. And to the mayor's point, the goal is, right, a bar or restaurant, a place, an establishment that serves alcohol is a sensitive area because alcohol compromises people's judgment, and as we've unfortunately seen in our own city, that has led to violent acts involving firearms. And I don't believe that, you know, to this question about, obviously the ordinance needs to comply with the Constitution, and the ordinance was not subject to this level of scrutiny back in 2014, which first of all, obviously was before the Bruen decision even came out, but also because as I understand it, the General Assembly didn't take up this charter change. So this is certainly very helpful, and because we want the ordinance to withstand constitutional scrutiny. With that said, you know, I don't know that, sort of to the mayor's point, if I would define a bar or restaurant that serves alcoholic beverages as being a sensitive location because of the potential consequences of becoming intoxicated and having your judgment compromised and making decisions to use a firearm under those circumstances, it's not less sensitive specifically because you're inside the restaurant as opposed to outside on the patio area or even in the parking lot, let's say, of, you know, a concert venue or a show venue. So that's all I wanted to add about sort of this point, I guess.
I might just also add, I can't tell if Tucker's still in the room or not. Mr.
Yes.
Liquor License.
Yeah.
Okay. Hi, Tucker. Liquor license expert. But our liquor licenses extend into those patios. So when we issue one as the local municipality, we issue a liquor license that applies for the indoor and outdoor space. So by logic, I'm not an attorney, obviously, but by logic, I would seek as mayor here consistency, predictability, ease of understanding for both patrons and, again, the bar owners and the city employees. One of the biggest things that was asked of us and why we have why people are really asking for the city, the bar owners in particular, is that consistency helps them. They know what they're required to do or not. The space for which this will be applying needs to be clear and consistent. And so by logic, places that are controlled, I think, by the liquor license should apply for this as well.
My last question is actually Senator White's question, and that is on page 3, beginning on line 3, subsection 4, where it talks about an exemption for the owner or operator of an establishment. Who is this intended to? Is that the owner of the business, the owner of the building, the license holder? So I just want to make sure that when we clarify this, we clarify it with the intent that you have.
I agree.
Well, so that is not a detail that I've discussed with anyone involved in drafting, but my interpretation would be essentially whoever's in charge, right? So if the highest ranked person, because certainly in the language in the original draft, obviously the person has to not be prohibited from possessing a firearm for other reasons in the first place, right? So I think I read the intent to be, if I'm the manager of the restaurant that night, I could possess a firearm for protection or safety of the establishment. Mayor, do you have a different interpretation? And certainly the owner would be the owner. So by operator, I interpret that to mean, I think the intent was sort of the staff person with the most authority to oversee the establishment at a particular time? Mayor, do you have a different interpretation?
My interpretation here would be, we really want to make sure the person who is holding the license primarily is the one I would focus on, because that person is signed up legally and gone through the vetting process that we have locally under state law. Again, I'm suddenly becoming a liquor license, but I did serve on the liquor license when I was a city councilor, so it's coming back to me. But there are parameters for which they have to sign off on legally, rules that they have to follow. When they don't follow the rules, there's penalties. That person holding that liquor license to me is the one who and I don't know the difference actually between, I assume that's operator of the establishment of licensing, though I'm looking again at Tucker. I can't see you, Tucker, but as in terms of making sure that all tracks and lines up. Now, it was interesting to hear your committee discussion on the owner of the building, of course. That is a different layer that is one which I think we would certainly be open for consideration. There are, as folks were discussing, I think virtually every bar in town is in a leased space. There is a piece around the property of the building itself applying here. But I would ask for you all to speak to really deliberate on who is ultimately in charge of the licensed location that's serving alcohol. That's the origin of what we're really getting at here, is who's ultimately in charge of a bar, which again is serving alcohol, which is the piece that's making the prohibition of firearms even relevant here.
Senator Clarkson.
But Emma, I hear you saying whoever's in charge that night. So, right.
Right, my city attorney, sorry, Senator. Yeah.
Mhm.
I was just, sorry, Senator. My city attorney, I haven't discussed about this nuance of it all. To me, I think going back, I'm trying to be consistent because that's what I've been trying to do this theme throughout my testimony here. Consistency of going back to the liquor license holder. There's a lot of people who will be different managers night to night. And I think for consistency of liability and whatnot, who's holding the liquor license is where I would be.
I agree. I mean, I think the license holder is a natural, but I can also see that you might want whoever is managing that, who's ever managing the establishment in real time. Might also want to examine.
Well, I would argue, though, that if we were allowed to make this local law, the real enforcers here need to be the Burlington Police Department. They are the professionals. They are trained. They are the ones who should ultimately be obligated. I never want to have folks feel like they need to have more firearms anywhere, period. That is my position, at least. And I certainly want to make sure that, and when we've been deliberating this with City Council and with voters here locally, it's been very clear that when we talked about enforcement, that is the job of the Burlington Police Department. That is an important distinction versus leaving that up to individuals to be enforcing our local law. So with that, I would say the BPD should be the ones who in that scenario.
Those are all of my questions.
Okay. I had one, and I think I asked before when we had, and I'm not going to remember the name of the establishment, but there was a bar owner that was in. How many establishments are captured here with the knowledge that both restaurants and bars are included? And you could certainly, I guess, make a case for there being a little bit of a difference between those two types of establishments. One of them, you assume that people are going to eat a lot of food and also imbibe. The other one is probably a little less likely, although they all have bar food, I guess, or whatever they call it.
There's actually percentages, I think, in liquor license. You have
Yeah.
to be 30%.
There is.
Okay. So, and I don't know Burlington as well as certainly you two. So I have no idea how many of these establishments would be captured with.
We could easily get you that information, Mr. Chair. I don't have that off the top of my head. We have quite a number of establishments, but as you've learned, there's multiple different kinds of liquor licenses. So I wouldn't be able to quickly quote that for you. I want to make sure you have an accurate number. But as I think what Senator White was just saying, there is a percentage required for folks to have food on premise if they have a liquor license. I don't remember that percentage off the top of my head. But just so I hear you correctly, you're looking for the first class liquor license because that's what we're discussing in terms of this charter. How many of those establishments we have?
First and third, I think.
First
and third? Okay.
And fourth.
First, third, and fourth.
Okay.
And clubs.
And clubs. And service clubs, not, as Tucker said.
Clubs.
I have to say that might have been the highlight of my hour, Tucker, was seeing your interpretation of club on screen. All right, and service clubs, yes.
Okay.
We'll happily get that to you. Thank you.
Any other questions? Your Honor and City Attorney, we both, we appreciate you both being here with us today. You certainly shed a little bit more light on the charter, and we'll hope that you have a great day.
Mr. Chair, thank you and the committee very much. We very much appreciate it. And we are more than happy to answer additional questions, especially technical, as you work on this amendment. We really appreciate it, and be in touch.
Okay, thanks.
Thank you so much. Take care.
Okay, committee, we have one more bill to look at, 472, the OPR bill. And we have one witness, I believe, on that. But let me suggest